Good morning, dear participants. Today we are delighted to welcome you in our joint event organized by three organizations, Ukrainian Arbitration Association, ArbCEE, and Ukrainian National Bar Association. And the topic of today's event is Ukraine as a seat of arbitration during the wartime. My name is Olena Perepelynska. I'm the president of the Ukrainian Arbitration Association, ArbCEE board member and chair of UNBA committee for ADR. And I'm happy to introduce our speakers. Today, Anna Guillard Sazhko, member of the board of the Ukrainian Arbitration Association, member of UNBA committee for ADR, Independent Arbitrator and Counsel, Oleksii Maslov, board member of the Ukrainian Arbitration Association, counsel at Avellin, Professor Volodymyr Nahnybida, vice president of the ICAC, International Commercial Arbitration Court at the Ukrainian Chamber of Commerce and Industry, major arbitration institution in Ukraine. And last but not least, Georgiy Grabchak, head of International Disputes Division of the International Cooperation and Representation Department, Ministry of Justice of Ukraine. Thank you for joining us today. So if you have any questions, participants, please use the comments tool in YouTube. And we will try to answer your questions in the end of the presentations. And I would like to start with a general topic of legal framework of Ukraine. And I would like to start and to ask my first question to Oleksii about Ukrainian arbitration legislation and whether there is any room for improvement. Oleksii?
Thank you, Anna. Well, there's always room for improvement. I guess we can witness that even with most advanced and internationally recognized arbitration seats, like, for instance, England and Wales. We all know that they're currently active work by the authorities in the United Kingdom and by lawyers there discussing how to improve their arbitration act. So, of course, each jurisdiction has room for improvement because arbitration is an evolving feature. It's basically a service that helps commerce, and as commerce develops, arbitration has to develop too. But speaking about Ukraine and Ukrainian lex arbitrii more generally, well, it's quite tried, but it is important to mention that Ukrainian arbitration legislation is based on ancestral model law, albeit its older version. Which ensures that at least the logic and the structure of Ukrainian arbitration legislation is familiar to international audience, to foreign lawyers, because model law is a very commonly referred to typical document. I would highlight that despite the war, despite the start of full-scale invasion in 2022, there actually hasn't been much changes or restrictions to Ukrainian arbitration legislation, which would prevent parties from arbitrating their disputes in Ukraine as before, or influence in any way their ability to recognize and enforce arbitral awards, or to get measures of court assistance in support of Ukrainian or foreign arbitration, which is quite outstanding and quite important. There are some limited exceptions with respect to sanctions or enforcement in favor of specific types of Russian state-related enterprises, which I guess would not surprise anyone and quite understandable, but otherwise it's more or less business as usual. And speaking about improvements, actually at Ukrainian Arbitration Association, we're actively working at this and engaging in this. And this is one of outstanding things about Ukraine, that here arbitration practitioners forming part of professional community of arbitration lawyers actually are actively working to assist parliament, to assist other responsible bodies in improving arbitration legislation. And just this year, we finished our draft law, our bill on improving Ukrainian arbitration legislation. So if we have time, I can go through 2 or 3 topics we're seeking to improve there, but Olena, please guide me if I'm not taking too much time already.
No, it's not the case. I think we could have a separate event and going into the details of our draft law on amendments of Ukrainian arbitration legislation. But I think what we could do is to highlight just topics, I mean, without going to the detail.
Yeah.
And this is important because a couple of weeks ago, I was asked by a foreign practitioner having now an arbitration seated in Ukraine under the rules of a foreign arbitration institution, and he asked, should I know something about legislation in Ukraine? So I would like to ask you this question first, and then probably you could explain some topics and some issues we would like to improve.
Yeah, totally. So I would say that there are like not much by way of underwater rocks. So the thing that could jeopardize you, some very unexpected or unorthodox things you have to be aware of in Ukrainian legislation. There are generally some issues, I would say. We can divide them into several broad categories. The first, I would say, be connected with arbitrability and the capacity of parties to submit their disputes to arbitration. So there's definitely room for improvement there in terms of widening the scope of dispute that are arbitrable, because I would say that the current scope of disputes is quite wide. But still, the most traditional disputes that are submitted to arbitration in Ukraine are disputes related to international trade. And for instance, disputes related to IP rights or corporate disputes are being submitted less than trade-related disputes. And there are also some issues, especially with bankruptcy, we're seeking to improve by this new law. The second big block relates to arbitration agreements and everything arbitration agreement related, from interpretation to validity to form of concluding an arbitration agreement to their effect and the ability to invalidate arbitration agreements before Ukrainian courts separately. We can, I guess, discuss this topic as we briefly mentioned before joining this webinar. There has been some important practice of the Supreme Court. And the last, I would say, is the role of Ukrainian courts. And there we seek to improve, first of all, the measures to collect evidence in Ukraine in support of international arbitration, also international arbitration seated abroad, and recognition and enforcement, primarily recognition and enforcement of interim measures granted by arbitral tribunals. So these are, I would say, the main topics we're working on.
Thank you, Oleksii. And you mentioned already the court practice. So we could imagine, so even the best arbitration legislation would be useless if it's not supported by respective court practice. So what is the situation in Ukraine? First of all, with regard to the enforcement of arbitral awards, I think this is a major topic many parties are interested in, both for arbitration seated in Ukraine or elsewhere, if the case involves a Ukrainian party or Ukrainian assets.
Yeah, first of all, the great thing here is that unlike in most situations when lawyers are asked some questions, they say, well, it depends. Here, we do not need to be that reserved, because in Ukraine, most of court judgments are available online through that database, which is open to anybody, which actually allows you not only to review the practice of Ukrainian courts, but also to review practice on specific issues and of specific courts. So basically, we can analyze how Ukrainian courts apply Ukrainian arbitration legislation statistically based on numbers and not on our own feeling as practitioners. And these numbers are quite revealing. So basically, what we have done as part of a working group in the Ukrainian Arbitration Association, we have analyzed more than 600 cases that were decided between 2006 and 2020. and then made a follow-up, which has not been published yet, analyzing cases in 2021, 2023. There are a lot of interesting statistics. We have already published part of them back in 2022. You can look for them at our website. Also, there are some articles describing those statistics. The most important thing is that in 90 to 95% of cases, parties seeking recognition and enforcement of an arbitrary award before Ukrainian courts are successful. So there are only a small margin of 5% or less of cases where courts refuse to recognize and enforce an arbitrary award, which is a very positive statistic. And I'm not sure whether courts in other jurisdictions can boast of such arbitration-friendly statistics. Another important thing is that we see that the most recent procedural reform from 2018, which basically concentrated all recognition and enforcement cases in two courts, Kyiv Appellate Court and Supreme Court, acting as a court of appeal in these kind of cases. It has shortened significantly the lengths of proceedings on recognition enforcement. And now the median duration is just slightly above 6 months for both instances. So
and this is even during the war, right?
Yeah, this is even during the war. And quite interestingly, we have not seen the war significantly impacting the duration of cases. Naturally, first 2-3 months, yes, but then the courts are just working more or less as usual on these cases, at least.
And any deviation in the statistics in terms of any grounds for non-recognition of arbitral awards during the wartime? Anything specific?
Interestingly, not much. I would say that there is generally a trend that, before, when I would say it's not connected to the war, but just with parties getting more acquainted with, and lawyers getting more acquainted with arbitration in general. Previously, the most popular rock star ground for recognition and refusal was the failure to notify. It's quite technical, but it's something that Ukrainian lawyers not dealing with arbitration understand and use. Now it becomes less and less prominent, and more sophisticated concepts like arbitrability are popular. Public policy, of course, is popular too, because it's quite flexible, or at least some lawyers think it is flexible and try to fit it on any perceived violation. So no, I would not say that there are any indications that, for instance, grounds related to public policy become more popular, or that Ukrainian courts become more, so to say, nationalistic in the way of giving more weight to the interests of the state. So we have seen some awards where the awards were granted against important state enterprises, and they tried to argue that the award should not be recognized and enforced on this ground because they're state enterprises and important for the economy. And the courts did not buy into these arguments and said that in this relation, these entities acted as commercial entities, so they should honor the commercial arrangements they reached. That's quite inspiring, and I guess very important, this position of the Ukrainian courts.
In many countries, probably public policy is a kind of a loophole or window, depending on the size, for many unsuccessful debtors in an attempt to block the enforcement of arbitral award. Is it fair to say that Ukraine does not belong to such states? So what is general trend and approach of the Ukrainian state courts with regard to public policy arguments?
I would say the important thing is that there is a very established line of cases with respect to public policy. So it's not like the courts, the judges have to reimagine what this concept means in each case. So of course it is not explained in legislation, but it is explained in the practice of the Supreme Court, in the practice of the Kyiv Appellate Court. And since the judges dealing with recognition enforcement cases are more or less the same, at least they are in the same two courts. It's not something unfamiliar to them. And the threshold the debtor under the award has to meet in order to prove that there was a violation, indeed a violation of public policy, is quite high. And the courts understand the difference between the awards violating public policy and the enforcement of award, for instance, violating public policy. They understand the difference between national public policy and international public policy, although it is not established directly in the legislation. So I would say the most prominent cases where you could encounter public policy are cases related to Russian entities or to sanctions, which once again, totally understandable. But otherwise, it's quite rarely granted.
Thank you. Another interesting aspect of court practice of Ukraine, again, not regulated, but initiated to a certain extent by the Ukrainian Arbitration Association, is submitting Amicus Curiae Briefs to the highest Ukrainian courts and arbitration-related cases. And again, first it was our initiative, but could you share with us any developments in this regard?
Yeah, it's really interesting because we actually have provisions for Amicus Curiae Briefs, but only for the Constitutional Court of Ukraine, not for other courts. And we indeed started this practice of trying to assist courts as independent parties without any conflict of interest on some complicated arbitration-related matters. This assistance is not always so to say, welcomed, at least for the public eye, by the courts. But even if they do not take it into account formally, they often still read the briefs. And the important development last year was that for the first time, the Supreme Court, proprio motu, asked us and asked the International Commercial Arbitration Court at the Ukrainian Chamber of Commerce and Industry to submit their briefs on a case related to arbitration agreements and their effect on third parties or assignment issues. And it was a very important development because it indicated that sometimes Ukrainian judicial authorities are interested in hearing out the views of Ukrainian arbitration practitioners. So we see this opportunity, and to scale it up a bit, established the Office of Amicus Curiae Brief Officer with the Ukrainian Arbitration Association to monitor the court practice and to decide to detect early interesting cases to intervene as Amicus Curiae.
We have a question. I think it's very specific and asking if it's possible to get access to the raw data on case law we analyzed and not the outcome of the analysis. Probably we could mention here our cooperation with Jusmondi, Oleksii.
Yeah, you actually, we are cooperating indeed with Jusmondi, who are publishing, based on our information, publishing Ukrainian court judgments, arbitration-related court judgments on their platform. Regarding access to core data, I'm not ready to answer this yet. We have to discuss it internally with the members of the working group.
So actually, probably to clarify, we provided all the cases we identify in terms of enforcement of arbitral awards to Jusmondi, and they are now publishing it. I don't know if they've published them all, at least from our previous analysis, but the idea is that they publish the decisions, and then it would be possible to analyze and to search those data using the very advanced tools on the Jusmondi platform. Yeah,
I have heard that they're introducing some artificial intelligence analysis tools, so it would be interesting to look at it.
Yeah. That would be much easier than using a Ukrainian court register. Okay, thank you, Oleksii. I think we could switch the topic and now discuss commercial arbitration in Ukraine. And so in Ukraine, we have technically several arbitration institutions dealing with international arbitration. So we have two laws, international commercial arbitration and domestic. arbitration, and the laws apply to different institutions. And in terms of international commercial arbitration, the major arbitration institution in Ukraine is ICAC, International Commercial Arbitration Court at the Ukrainian Chamber of Commerce and Industry. And I'm happy that we have today Vice President of ICAC to ask more about the statistics of this institution during the wartime. So what is the situation, Volodymyr?
Thank you. Thank you, Olena. Foremost, let me congratulate you on hosting this excellent arbitration event, and let me express my gratitude for the invitation to participate in this forum. As to the general statistic, I would like to point out that according to Ukrainian legislation, ICAC are the only, as you correctly said, the only national permanent arbitration institution which provides dispute resolution services in cases where a foreign company or company with foreign investment involved in disputes. So the ICAC resolve only international disputes. UMAC, Ukrainian Maritime Arbitration Commission, could resolve both national and international disputes. But about UMAC, maybe I mentioned in my further responses. As to the general statistic, in 2023, ICAC received about 600 cases, namely 584 cases, which was 50% more than in 2022. In 2022, ICAC registered 373 cases. A lot of cases were influenced, of course, as we could understand, by the introduced martial law in Ukraine, and exist logistical transportation issues, disrupted logistic chains, etc. Nevertheless, the tendency in this year, the tendency 400 plus cases remain also, and since as of today, we have received 343 registered cases as of now. In terms of speed, maybe 90% of cases are considered within 6 months from the date of formation of arbitral tribunal. And in terms of general industry of mentioned cases, in 2022, in 2023, most of cases were connected with metallurgy, agricultural business, energy and natural resources, food industry, and chemical industry. From 2022, extremely gross number of cases connected with the defense industry. In 2022, it was only 2.4% from general number of cases, but in 2023, the number of disputes connected with defense industry increased up to 7.7%, and in this year we could see approximately the same number of cases connected with this industry. This is general overview.
Yeah, just a few clarifying questions. First, what are the languages in all those proceedings, and do you see any trends, languages of arbitration, I mean, and do you see any trends? And so you mentioned that ICAC is acting only for international disputes, but are there any disputes not involving Ukrainian companies?
Yeah, thank you. In terms of language, for example, in 2022, we had about 50% of cases considered in Russian, 40% of cases considered in Ukrainian, and about 7% of cases in English. In 2023, the number of cases considered in English increased up to 10% and continues to grow. And for now, we could see that, from my standpoint, in this year, we will have about 50 or even 15 or even 17% cases and arbitral proceedings conducted in English. One interesting moment that every year we have, as you asked me, every year we have certain number of disputes where both parties, claimant and respondent, are non-Ukrainian foreign companies, of course. All these cases are also conducted in English, of course. And for example, in 2023, it was 16 cases where the claimant side were companies from For example, Estonia, Bulgaria, Poland, Turkey, Cyprus, Spain, Switzerland, and on the respondent side were companies from the United Kingdom, Switzerland, Poland, United Arab Emirates, Spain, Turkey, and some other countries. In 2024, we have, as of now, we have received 8 cases with non-Ukrainian participants, in which, as the claimant and the respondent respectively, involved companies from Hungary, United Kingdom, Estonia, Lithuania and Switzerland, USA, United Kingdom, Poland and Canada, United Kingdom and Poland, and other countries. In general terms, such kind of situation.
Oh, okay, thank you very much. And my last question, with regard to gender diversity in appointments of arbitration, this is a topic which is important for many arbitration institutions, as normally, not normally, but even the institutions striving to improve the general statistic always complain that even if they do their best and having like 50-50, then the parties could spoil their statistics when they prefer not to appoint female arbitrators. So what is the situation in ICAC? I know that ICAC joined the ERA pledge on equal representation in arbitration, but what is the actual situation?
Thank you for your question. Actual situation demonstrate that the ICAC demonstrates again the best result. I guess the best result in adherence to the principles of gender equality among arbitration institution. It was presented on 20th of September 2022 at the Congress on the International Council for Commercial Arbitration. And for instance, in 2022 there were 40% women arbitrators involved in consideration of cases at the ICAC. In terms of formation of arbitral panel, 48% women arbitrators were appointed by the parties to a dispute. Besides, as of now, in the ICAC recommender list of arbitrators, there are 29 of women, 30% of members of the ICAC presidium are also female, and we are proud that 100% of the ICAC secretariat consists of women.
So the parties actually appointed roughly 50-50, right?
Yeah, 50-50, correct.
Yeah, that's a great statistic, I think, and we could be proud of parties using the rules of ICAC. But okay, it's good to have many cases administered by this institution, but it is important to know the statistic of their setting aside by the Ukrainian court. This is, of course, connected with the previous presentation of Oleksii, but he mentioned mostly enforcement of arbitral awards. And of course, as the ICAC is a major arbitration institution in Ukraine, it's very easy to understand the general situation by knowing the statistic of setting aside of the ICAC award. So what it is?
I think that it is for the business, it is the most important statistic, such as one thing to obtain an appropriate arbitral award, but another thing to hold it and to perform, of course, and enforce appropriately. In this respect, I have the statistic from 2015 until 2023. In general terms, during this period, ICAC has rendered 2,774 arbitral awards, rendered according to the ICAC rules during last 9 years. 164 arbitral awards were challenged, which consist 5.9% from the general above mentioned number, and only five arbitral awards were set aside. Its statistic is of January 2024. So the general statistic during the last 9 years.
5 awards in 9 years.
Five, correct. 5 awards in 9 years. It's about 0.2% from the general amount of cases considered during the last 9 years. In 2024, we have information about one annulled arbitral awards by the Kyiv Court of Appeal, but as of now, ruling of this court challenged by the party to the Supreme Court, and we are waiting for the final decision of the Supreme Court in this case in the mid of October. In this respect, I have to say that such statistic demonstrates the arbitration-friendly approach, first of all, of Ukrainian court system. It was mentioned by you, Olena, and Oleksii previously, and of course, simultaneously appropriate quality, I think, arbitral awards rendered according to the ICAC rules. And in terms of arbitration-friendly approach, I would like to mention for example, latest ruling of the Supreme Court of 13th of August 2024, posted on the court register just 4 days ago, in which Supreme Court, based on the practice of the European Court of Human Rights, in particular, has ruled that the national court authorized to consider matters of the validity of arbitration agreement only in strictly defined situation, and Supreme Court concluded that the right to access the court with an independent claim for invalidating on an arbitration agreement is lawfully restricted in Ukraine in order to ensure appropriate pro-arbitration regime in Ukraine. And as a general rule, court stated, the consideration by a commercial court of a claim seeking to invalidate an arbitration agreement constitutes unlawful interference in the jurisdiction of the arbitral tribunal. I guess these conclusions clearly demonstrate that Supreme Court and Supreme Court, whose decisions are binding for the lower courts, of course, fully support parties in their right to resolve commercial disputes through arbitration, and of course, statistic of setting aside clearly demonstrated.
Oleksii, you want to something?
Yeah, I wanted to ask Volodymyr if he sees any trends with respect to number of challenges throughout the year. So you said that there are 164 challenges for 9 years. So are they distributed more or less equally? For instance, I don't know, 20 or 15 challenges each year? Or do you see the trend that as Ukrainian courts very rarely actually grant the set-aside application, parties resort to this less and less? Just wanted to know if you know the distribution through the years.
Thank you, Oleksii. Nice question. I don't see, frankly speaking, I don't see some trends in this respect. From 164 cases, 41 arbitral awards were challenged in 2021. It's approximately 25%. In terms of each year, I have appropriate statistic. For example, in 2015, it was 21 arbitral awards challenged. In 2016, 16. In 2017, 17 appropriate arbitration awards. Yes. In 2011, in 2018, it was 10, only 10. 19, 17, 20. Only 8 arbitral awards. 21, 41, as I mentioned before. 22, 22. And 23, only 12.
Okay,
only
I see.
12. Yes. So
it seems like it just depends
I don't see
on how
some trends.
How litigious are parties in a particular year. So there is no trend. Thank you.
But it's interesting that in 2022 and 2023, there were zero arbitral awards set aside.
Yeah, that's great.
I think we should also mention that everyone could actually see the statistic on the website of ICAC.
Yes.
It is publicly available on annual report, so you could see previous annual reports of the institution and see the statistics of setting aside, which is really useful. And ICAC is monitoring the statistics regularly, and actually, according to Ukrainian procedural legislation, the Ukrainian courts often ask the institution to provide the case material, so the institution knows exactly that there is a pending setting aside proceedings. Okay, so probably the last question in commercial arbitration section I would like to ask is about activity of any other institutions in Ukraine. As I understand, the Ukrainian Chamber of Commerce of Industry also is like the mother institution for another arbitral institution you mentioned today, Ukrainian Maritime Arbitration Commission, and also ICAC has rules of assistance to ad hoc arbitration. So do you have any statistics of these two rules applicable by the parties in Ukraine?
Yes, some cases from 2011, the ICAC provides appropriate assistance in dispute resolution according to the answer to arbitration rules. During the last 3 years, the ICAC has provided assistance in two cases. One of which is currently pending. And as to the UMAC, from 2014, when Russia annexed Crimea, the number of cases in this respect, I mean maritime disputes, significantly decreased. For instance, in 2011, UMAC considered 15 cases. In 2012, 10 cases. In 2013, 13 cases. In 2014, 18 cases. During the 21, 23, 24 years, UMAC received only 15 cases for the last 3 years. And but 8 cases, 10 cases in this year, and 8 cases are still considered. So I think it's clearly demonstrated that we have different rules, but it depends on the kind of rules. Of course, commercial arbitration in this respect has the most number of registered cases. But we have, I have to mention that we have another rules. It's mediation rules from 2023. We appropriately prepared and established mediation rules with combined procedure. And as of now, we have 3 cases, 3 cases. In 2 cases, the mediation based, which were based on the hybrid format, arbitration, mediation, arbitration. And in these cases, mediation were not successful. In one case, mediation were successful, and parties reached the solution and concluded the appropriate mediation agreement.
That's good to know. So this area is indeed developing in Ukraine. There was a new law on mediation adopted just a couple of years ago. And probably I also need to mention that in Ukraine, there are no limitations to have arbitration under the rules of any other institution, if the institution so allows, and so we do not need any, I don't know, licensing, any permission, etc., etc. And I've heard, so previously the foreign institutions were quite cautious probably to have arbitration seated in Ukraine. And so I regularly asked the institution, okay, do you have any statistics? And this year I've heard from the parties that now we have an institution, we have an arbitration seated in Ukraine under the STC rules. So again, this is difficult to monitor using the court register, because we could see on the enforcement of certain side, I mean, that is post-arbitration proceedings, but it would be interesting to see the trend in general, because I have seen in the court register more and more cases on ad hoc arbitration under ancestral rules. So we'll see if it's a trend or not. But now let's switch. Thank you, Volodymyr. And now let's switch to investment treaty arbitration. And I would like to ask Georgiy about general investment protection system in Ukraine. So because I should mention also that the Ministry of Justice is the state body responsible for protection of the state, at least, and you could also clarify the limits if you wish. So, and of course, dealing with investment treaty arbitration involving Ukraine and Ukrainian state parties. So, Georgiy, what is the investment protection system in Ukraine now?
Yeah. Good morning, colleagues. Nice to see you all today here. Thanks for invitation. So, about some general characteristics. Ukraine is a very active participant in the international investment law environment. We take part in UNCITRAL working groups. We also monitoring all other developments and trends in the international investment law. In particular, we deeply monitoring thoughts about the creation of something like International Investment Court or whatever it would be, and like ECT trend when other countries decide to terminate this agreement, etc. We have, in addition to some common arbitration conventions like New York Convention and ArbCEE Convention, Ukraine is a party of more than 70 bilateral investment treaties. It's a big amount, please trust me. But we haven't stopped. We continue to negotiate a new bilateral investment treaty, and also we are in the process of amending of some old bilateral investment treaty, taking into account our previous experience, our previous experience in ISDS, and general practice of investment tribunals all over the world. And to speak the truth, we have not an easy task on this track, because you know that making Ukraine more attractive for foreign investments is on the government's permanent agenda, even in the wartime. And considering this point, from the one side, we have our responsibility is to create and develop a legal protection mechanisms for the foreign investments to make Ukraine more attractive. But from the other side, Ukraine during last 12 years faced a lot of bad faith claims from the claimants who are struggling to impersonate bona fide investors. And it was possible inter alia because of the very broad and, let's say, democratic, like old-fashioned bilateral investment treaty definitions. So nowadays, we try, considering all these both points, we try to find a just balance between the interest of the foreign investors to have the right to claim Ukrainian ISDS and the state interest to legitimately limit this right for the bad faith claimants. And what concerns particular disputes, Ukraine actively participates in pre-trial negotiations and tries to find amicable solution where possible. In all cases where we can do it, we actively communicate with the claimants and other state authorities. And we have several cases where we invited the claimants to our confidential intergovernmental working group to discuss deeply the case details. And you all know it's not a secret that Ukraine is a very specific state from the legislative and policy perspectives. And considering this point, I suppose that one of my personal responsibilities on this position is to have a fruitful, open dialogue with the claimants. And practice also demonstrates, it's very interesting that sometimes claimants need only a good explanation of why something goes wrong or to get some instructions, not instructions, but advices maybe how to decide this problem. And we have really a lot of cases which closed on the pre-trial settlement where we haven't paid any cent, but we closed amicably, and everyone was satisfied by this result. And also, we are very open to any relevant and mutually beneficial dialogues. We have, like, one side when the claimant is not deeply familiar with a particular legal system. And from the other side, we have a communication with other state authorities who are decision makers in some or other important for particular investors questions, and they are not deeply familiar in ISDS. So our second main responsibility is to create a fruitful dialogue and try to explain to the state authorities why this claimant has these claims and why they are grounded in such way, and to explain the potential claimant some nuances of the Ukrainian law. And it's like a good side of this point. But we also have, unfortunately, a bad experience when the claimant abused his right to claim Ukraine, and he abused the case circumstances. You know that investment disputes there, they have a lot of facts, a lot of proofs, a lot of information which is relevant for every particular case, and the Ministry of Justice needs a lot of time to find these inaccuracies, but we do it not bad. Not ideal, but not bad. And when after we identify all these nuances, all these inaccuracies, let's say correctly, then we carefully and politely explain to such investors or to such claimants why they are wrong, and provide some information. And we also have several cases which closed on this stage. So these parties like don't have any claims to Ukraine for today. And also like what concerns disputes which go to the investment arbitrations, we are also very active. We don't use a tactic where we totally ignore any proceedings, even the craziest proceedings. You know, in the end of 2022, we received the request of arbitration where the claimant asked the tribunal to annul some sanctions of the Security Council. And we understood that it has a lack of legal merits. It was really strange claim, and now I think that some students experimented with us, maybe, but we asked and we moved within the procedure, and everything was according to all procedural requirements. And the last point the last point from my side on this question, as my colleagues are more good, I think, with the local cards issues, because we don't represent Ukraine in the enforcement recognition enforcement proceedings in Ukraine. It does our another structural unit, which like for the courts, let's say. But I really see crucial changes from 2017, and this practice, it becomes more and more reliable and pro-arbitral, but without any fanatism. You know, when some when it's not like our courts try to demonstrate that they like arbitration. I think that not every judge likes arbitration. Some judges don't not hate, but they think that it's something like, it's not the court, it's something for some private entities. But they provide a really good and balanced approach in deciding these cases for recognition and enforcement, when they, from one side, demonstrate the state position in the public policy issues or some other issues which are important for our courts, but from the other side, they are ready to accept foreign thoughts in the case, foreign law, foreign approaches, etc. So it's very good, because you know that any good arbitral award in your favor costs nothing when you cannot access the enforcement of this award. So I think I resume. I think that this mechanism is still not ideal, but it works not bad. Of course, we are not United Kingdom, but we can we have a good progress, we have a good results, and we move very quickly on this track.
Thank you, Georgiy. I think what is also interesting is the general statistics. So you mentioned that high share of settlements in the pre-arbitration stage, but we all know that Ukraine is quite often responded in arbitration proceedings, in investment treaty arbitration, and there is certainly a statistics of wins and losses, and so or settlements. And do you have such statistics? And what Ukraine do when it loses arbitration?
Okay, nice question. Thanks. I can confidently state that Ukraine has a good ISDS track record. According to information available for us, Ukraine has already taken part in 16 fully finished cases. I mean, not only arbitration, but all post-arbitral proceedings, like setting aside, recognition and enforcement. So it's fully finished projects which are closed, and we moved all this to the archive, and that's all. And from these 16 cases, 3 of these cases were terminated by the amicable settlements with the claimant, and all these settlement agreements were fully fulfilled. What concerns final awards, Ukraine has 5 awards in its favor, and it's a very big amount, let's say. And what is also very interesting that I think, as Oleksii said, rock stars of claims against Ukraine is an expropriation, fair and equitable treatment, and particular denial of justice claims. It's a part of FET, of course, but it's very popular. But some of these awards, which in our favor, the tribunal haven't agreed with these arguments, and they denied all denial of justice claims. And it's very glad to see, because you know, our Ukrainian courts, they're also not ideal, let's say, but they have a lot of criticism, and I think there is no well grounds for such a big hate of this system in general. And some of our arbitral awards fully confirm my thoughts about this. So what concerns other cases where we lost, all these cases, not all, no, let's say that we lost 8 cases. But in all these cases, the recovery amount was significantly decreased, and in some cases it was decreased for more than 90%, and it's a very good result for us. And what we do with the lost cases, of course, without prejudice to any right for the Ministry of Justice, we use all procedural defenses which we can in every case. And you know that investment arbitration is has a lot of similar issues with commercial arbitration, but it's not the same thing. I mean, some issues of jurisdiction, for instance, and some other issues, international public policy, etc. So they're more difficult if we compare it with the commercial arbitration. And in a lot of our cases, we have really legal questions which we need to decide before we move to the recognition and enforcement. It concerns in particular whether the investor is an investor, whether this claim is covered by the jurisdiction of the particular tribunal, etc. So, and about statistics of enforcement, it's the most important point, I think, for all stakeholders, for private businesses. So all cases where we lost, and where we exhausted, if necessary, all our procedural defenses, we simply pay money. So all these cases which we lost, they enforced in full. Now we have two cases, only two cases in the enforcement proceedings, and one of them is in process currently. In another case, we identified Russian stakeholders, beneficiaries, and considering the resolution of the Cabinet of Ministers number 187, we freezed the enforcement on the wartime, and until the moment of, I forgot what exactly this resolution requires from Ukraine, but until this moment it freezed. So, but what concerns other cases with, let's say, usual not Russian or not bad faith investors, we pay money, and we do it even in the wartime, and we do it not bad, considering the lack of budget for this program. So I can assume that any investor can rely to get this money if he wins the case. So that's my point.
That's a very good news, a piece of news for investors. And very briefly, I mean, impact of the war on pending cases. So are they suspended? Are they going on? And anything, if anything changed after the start of the Russian aggression? But again, very briefly.
Yeah, okay. Sorry, yes. Very briefly. So if to compare with this amount which I described, now we have 16 pending cases. 15 pending cases. So we have 16 finished cases for last 20 years, one more time, and now we have 15 pending cases active. And from the very beginning, all cases were suspended, but now in almost all cases, the suspension is lifted. So we actively work on these cases. And you know that full-scale aggression and COVID negatively impacted on our procedural schedules, and a lot of procedural steps were postponed. And because of these factors, we have now such amount of the cases. But we expect that the significant part of these cases will be finished during next 2 years. I think everything is okay with it. However, despite all these difficulties, in my personal opinion, the quantity of the work on the cases by the Ministry of Justice impact becomes more and more tangible. So despite this unprecedented for us amount, we deeply work on every case, considering the previous experience, considering legal advices from our legal counsels, and we formulate a really good position in our pending cases. We have a good success to win a lot of them, if not all. Of course, we have, as you probably know, several cases in some or other way interconnected with Russian Federation, and it's number one now in my division, and it's nothing to say that these cases are the most important for Ukraine, and we will argue our position and defend our position before any international fora if necessary. And one of the recent trends, the last point from my side, that we expect very soon the first cases connected with the confiscation of the Russian assets, considering the amended law on sanctions. And this step was carefully overthought by all the stakeholders, relevant stakeholders, and I can confidently state that we are ready for these battles. We are ready to argue that we have the right to confiscate these assets. That's why we have the right, and why it's not it's full. We fully comply with all our international investment law obligations.
Thank you very much, Georgiy. And the last block of question I would like to discuss today is the arbitration community and arbitration practitioners in Ukraine. And this, of course, depends on education, on practice, and on other aspects of building and educating Ukrainian practitioners. So, and I would like to ask Anna, first probably about education, arbitration education in Ukraine, and probably some programs, foreign programs, Ukrainian students or practitioners are involved in.
Thank you, Olena. I think that we can divide the education programs in programs organized and taught by the university, and also programs and different opportunities provided as in Ukraine as outside. If you take your national universities, already some universities offer courses on commercial arbitration, and also there are already textbooks available in Ukraine on arbitration. But very often these courses are taught by academics without practical knowledge or experience of arbitration. And some universities also invite as guest lecturers practitioners who have practical arbitration experience. In terms of ad hoc programs or programs outside of universities, one of the things that we like, I'm saying we because we were members of the organizing committee with you and Oleksii, that we organized the Ukrainian Arbitration Academy. And the idea of this academy was to give opportunity to the Ukrainian audience, not only to the students, to learn from the best arbitration practitioners in the world. And we had 16 guest lecturers, and in total, I think the total number of hours was around 30. So I think it's not all LLM, even foreign LLMs give this opportunity. And we received very positive feedback from the audience, and even like for we did not record, so but we kept a lot of knowledge. I mean, myself, I was very excited to listen to these lectures. Also, Ukrainian Arbitration Association, we organized the school before the academy. We organized schools for many years, where we also invited foreign and local practitioners. I forgot to mention that for this academy, we had 129 practitioners. So as the Ukrainian Arbitration Association, we try to constantly concentrate time and efforts to provide different opportunities for students, young practitioners, and not only. Another great opportunity for Ukrainian lawyers is also to follow courses in Ukrainian. And this is, we have ELSA Arbitration School, which was organized for the second year this year. Also, ELSA organizes cross-examination competition for Ukrainians. If you look at foreign opportunities for Ukrainian lawyers, I think that we can single out two arbitration academies, academy and school. Arbitration Academy in Paris, where last year we have an agreement with the organizing committee, and they accepted many students from Ukraine. And also we cooperate for the, I think it's second year with Basel Academy, Arbitration Academy, which is considered one of the best in the world, and Ukrainian students receive scholarships to participate online and offline. Also, since the beginning of the war, different universities increase the number of Ukrainian students and provide scholarships. But in general, I think that here is one of the discussion now that whether the students who leave Ukraine to study abroad will want to come back or will be able to come back. And also another great opportunity for Ukrainian young practitioners and students is participation in Vismut. And I believe that in Vismut every year there are a couple of teams from Ukraine. But also I believe that last year or 2 years ago, a team from Ukraine won cross-examination moot foreign cross-examination moot. So Ukrainian young practitioners and students demonstrate great achievements on the international level. And I think that like in 5-10 years from now, we will see more and more Ukrainian names on the international arena, not only Eastern Europe or Ukraine.
Yeah, another development of during the wartime is that many Ukrainian arbitration practitioners left Ukraine and started working either on temporary base like secondment or permanently in many different law firms outside Ukraine. So how do you think, is it good or bad, and what are the perspectives for those lawyers?
I think this is great. Because first, Ukrainian practitioners, they get to work with the best lawyers in the world on the biggest cases. And it's how you learn that, for example, in France, the educational system foresees that you need to have an internship of between 18 months. Sometimes you can be a trainee for 3 years. And then during this time, you work with different law firms. So I think the more exposure you get, the more opportunities you have to work on different cases you learn, and you become a better lawyer. I know that some lawyers, some young practitioners, they came back to Ukraine. Some continue to pursue their LLMs. I think that in general, this is and some were hired as associates or senior associates. So I think that this is, in general, for Ukrainian arbitration community, it is great. And I think that, usually we don't see many Ukrainian names abroad. I just I think maybe we are like around, if you take not trainee students, maybe we were like around 50. Now I think that we are maybe 200. So I think that these people, they keep connections with Ukraine among themselves. In Paris, I met regularly, I met students and practitioners from Ukraine. So I think that in a couple of years, like now it's difficult to say, but I think that in a couple of years, some of these practitioners will remain in Europe or in the US, abroad, but they will keep their relationship with Ukraine. And the same, some we will come back, but we will have more friendly and more strong arbitration community. So it's just like that, to help each other, to inspire each other, and to support each other.
Thank you, Anna. And what about the Ukrainian arbitrator? So we've discussed like younger practitioners arbitration practitioners from Ukraine in general, but what about Ukrainian arbitrators? What is the situation? What are different initiatives to promote them?
Yeah, so two initiatives I'm proud of, again, with the Ukrainian Arbitration Association. We created, it was before the war, the list of lawyers able to arbitrate Ukrainian disputes. And there we have Ukrainian practitioners based in Ukraine, Ukrainian practitioners from abroad, some foreign practitioners who have experience arbitrating or working on Ukraine-related cases. And I think that this list was a success because even if not be able, many of people listed there were not yet appointed as arbitrators, but I know that many institutions refer to this list, they check this list. So I think that in terms of feasibility, it was very useful. And another initiative, which was also very practical, it's during the first months of the war with Ukrainian Arbitration Association, we started publication of profiles of Ukrainian lawyers with hashtag appoint Ukrainian arbitrator. And I think that I don't know whether some of the practitioners were appointed, but I know that some people, because of this, but some practitioners received the appointments. I think that in general, visibility, the more visibility Ukrainian practitioners get, is the better, because but this does not depend only on the skills or experience of Ukrainian lawyers. It also depends on the institution and general exposure to arbitration. With Olena, with you, we published a couple of posts on the statistics of the leading institutions on appointment Ukrainian arbitrators on applicable law. And we saw that for now, for example, if you take ICC, we had only 2 Ukrainian co-arbitrators, 4 parties from Ukraine. With this, it was only 1 party from Ukraine and 1 applicable law, Ukrainian law is applicable law. With the Swiss Arbitration Center, only 5 parties from Ukraine without Ukrainian arbitrators. With the LCA, we had 1 Ukrainian arbitrator. With Stockholm, there were 7 parties and at least 3 applicable, 3 cases where Ukrainian law was applicable. And in VIAC, so as they presented their statistics, we could see that at least there was 1 case where Ukrainian law was applicable and there were Ukrainian parties. I think that in general, the
And
more...
that all for 2023, right?
2023. So we see that, I think that if we take statistics from 10 years ago, the numbers would be much more sadder. So we see a positive trend, but again, it's one of our strategies, philosophies of Ukrainian Arbitration Association is that we promote Ukrainian practitioners. We also promote Ukraine as a seat of arbitration, Ukrainian law as applicable law. So it's up to the parties also to include Ukrainian law as applicable law, or maybe include Ukrainian law as Ukrainian language. So I think that we've seen with the statistics that there are cases in Polish, in Romanian, within the international institutions. So I think that here it's like the whole infrastructure needs to evolve, and we need to encourage more companies, decision makers to consider how they can build, how they contribute to the improving Ukrainian community and give more opportunities to Ukrainians. I think that in general, like in 10 years, the situation got much better, but we still have a long way to go. And with the Ukrainian, like, I think that now this is with in general, how Ukrainians now known worldwide, because I mean, when I remember that when I arrived to France and like in 2011, 12, and I said I'm Ukrainian, some people were asking, where is Ukraine? So now everybody knows where is Ukraine. Everybody knows that Ukrainian people are very strong, resilient. And also in general, I think in the last 10 years, there are more and more very professional lawyers and working on commercial cases, not only as arbitrators, but as practitioners on investment cases. So in general, Ukrainian practitioners became more visible, but still we need to work, continue working, not to stop what we achieved today.
Thank you, Anna. I always say that we have many talented, gifted, and hardworking students and arbitration practitioners. And I know feedback from some either foreign education institutions or law firms working with Ukrainian at the beginning of the war, and they all were positively impressed by the quality of work and knowledge Ukrainian practitioners showed and delivered. So I am pretty sure that this is indeed a way to go, and we will see more and more arbitration practitioners from Ukraine acting as counsel and as arbitrators in various arbitral proceedings, both citizens Ukraine and beyond. But it is good to know that in Ukraine we have a good pool of highly qualified arbitration practitioners, and that is important for any arbitration seated in Ukraine. So you could have a good choice of arbitrators, of counsel or co-counsel, of experts, and also for any post-award or proceedings, you also have a good choice on a local market if you need any help. So with this, I think we could close the formal part. We still have some questions. So I've noticed in the chat at least 2 questions to our other speakers, and then I will sum up the entire event. So first question to Georgiy. So you mentioned that Ukraine pays to foreign investors when it loses the cases and after all the post-award proceedings, etc. So the question, if do you think it is reasonable to pay compensation during the war when money are important for the state and citizens, is a doctrine which would deal with this issue?
Thanks for your question. So, as I said from the very beginning, Ukraine has a very specific legal environment. So, and first of all, I think that despite the war, of course, if we have the possibility, and we are very limited in these financial possibilities, but every year we receive some amounts for these specific necessities, and it's one of the specifics of our budget legislation. And please trust me, it's the craziest and the most unlogical thing which I ever faced. But we can we are not bad in these issues as well, but still we have things on which we cannot influence. So our in a nutshell, our financial system functions on the yearly basis. So every year we receive some money for some reasons, not only we, but every authority, every state organ or state entity, etc. And we need to use it. So if we don't use it, it's for unclear for me reasons, it disappears.
Burn out.
It disappears. Yes. On the 21st of December, all money are transferred like in Zolushka. I don't know how in English it's named, but
Cinderella.
Yeah, thank you.
Cinderella.
Yes, like in Cinderella, literally. And if you don't use this money, they disappear. So it's the first reason. The second reason, it's our obligation, and if we have the possibility, we need to do it. The third thing is a process. So yes, we can stop. Theoretically, we can stop all the payments if we have good reasons for it, legitimate, I think. But we will. But in future, we will pay more. So, and considering all this history with loans for Ukraine, we try to close all our financial obligations when we can. If we can, we do. So please don't do something tomorrow if you can do it today. And it's of one of our how to say.
Motto.
Motto.
Yes, one of our mottos, and so that's all. The answer is very simple in reality.
Yeah, and I think we could also add that in terms of as Ukraine is trying to attract foreign investments, and even during the wartime, it's on the agenda of the status is really important. Yeah.
Yes, and very short remark considering the last topic. Ministry of Justice is very open for students' practice, for young specialists, and we are very welcome. If not my division, we have a lot of other internationally interesting work and please write me per email, and really the best practitioners would become an offer. We already have such one person who works with us. And also we have open position of my deputy. And if you are interested, please join us. We have a lot of interesting work, and it would be a good experience. Thank you.
Yeah, I see that. So some Ukrainian practitioner might obtain new career opportunities after today's webinar. That's indeed interesting to know. And the last question I see in our comments is probably to Oleksii, or to everyone. So based on your experience, what were the widest cases when Ukrainian courts set the public policy?
Yeah, thank you.
We'll probably start with Oleksii, but if anyone would like to add, so please feel free.
Yeah, thank you. The good thing is that it's really hard for me to answer this question, because for the most part, I cannot think for the last, I don't know, 4 or 5 years of any crazy ground that were actually supported by courts. I can think of crazy ground that were argued by parties, but were ultimately not successful. For instance, if party says that the fact that an arbitration agreement was concluded through an exchange of letters, it somehow violates Ukrainian public policy, or if the respondent is a state company, it somehow violates the enforcement against it, somehow violates public policy, or where the parties try to argue that some procedural violations or perceived procedural violations amount to the breach of public policy. But those are all just arguments advanced by parties that were ultimately not supported by Ukrainian courts. Where I do see some, I would not say weird, but a little bit conservative interpretations by Ukrainian courts is the area of arbitrability, because some courts do confuse the, and I would grant them that it's quite complicated, the issue of jurisdiction, or the issue of how the jurisdiction is distributed among Ukrainian courts, and the issue of arbitrability. And there is, especially during the first instance court review, there may be some room for weird court practice, where the courts say, for instance, that if Ukrainian procedural law said that all cases against state authorities shall be heard by a certain Ukrainian court based in Kyiv, for instance, they interpret it as conferring an exclusive jurisdiction to this court, tramping all arbitration agreement. We have seen such cases, and actually, here I come back to my point on Amicus Curiae Briefs, because just last year, we actually submitted an Amicus Curiae Brief in one of such cases, because we understood that if this position is supported by the Supreme Court, this would create a very dangerous precedent, significantly limiting arbitrability of disputes in Ukraine. And I'm happy to say that the Supreme Court saw the reason here and supported the correct interpretation, and dismissed this argument advanced by a bad faith claimant who just wanted to avoid its obligation to arbitrate dispute outside of Ukraine. So yeah, there are some weird reasonings, but in terms of public policy, all is good. So nothing to answer to this question, which is good.
Probably I should also mention that we are going to publish the statistics for this 2021, 2022, and 2023 soon. There are a couple of cases where public policy was in play, so I think we will simply give full information in our overview, and everyone would be able to see if it's good or not good, and whether it was justified or not. Any other comments, or I could wrap up? I think we are
just mentioning public policy is a very unruly horse, as we know.
Yeah, but still, I would say that Ukrainian court practice in general is quite arbitration friendly in this regard. And
correct, absolutely.
It's very difficult to meet the threshold established by the Ukrainian courts. So to wrap up and to just summarize what we've heard today, so Ukraine is a ancestral model law jurisdiction with a very few deviations, so you should not expect something strange or when you have an arbitration seated in Ukraine. You should probably know more about arbitrability and should be cautious if your case involves any Russian or Belarusian element. Otherwise, you could safely arbitrate your disputes in Ukraine. And we've heard that it's close to impossible to set aside any arbitral awards rendered in Ukraine. And vice versa, it's 90 to 95% probability that you will succeed in enforcement of arbitral awards in Ukraine against the Ukrainian debtors or Ukrainian assets. And Ukraine generates or hosts hundreds of international arbitrations each year. And Ukrainian arbitral institution ICAC is having a quite impressive caseload during the wartime, and the war has not decreased but increased the number of disputes, and it has not any negative impact on court practice related to arbitration. And you could expect having your arbitral award or your state court decision during quite short time period. And in terms of investment arbitration, so Ukraine has over 70 BITs and has lost only 8 cases so far. Also, it is a quite popular respondent to a certain extent. Yes, it concluded 16 cases and now has 15 cases still pending with some expiration of success of many, if not all of them. And Ukraine pays its debts. So when it loses and after all the post-award proceedings, it pays the debts to foreign investors. And the last point, that Ukraine has a good pool of arbitration practitioners of different age and categories. So you could have a good choice of arbitrators, counsel, experts, etc., for your cases seated in Ukraine or involving Ukraine in any extent. So with this, I would like to thank all our speakers and all our participants for being with us. This video will be published and we will be happy to distribute it later. And we are going to have separate events covering some aspects we discussed today. So stay tuned and follow our pages or channels in social media. So thank you very much. Have a good day.
Thank you, Olena, for inviting us.
Thank you.
It was a pleasure to speak. Bye-bye.
Take care.
Bye.
Bye.